Good evening, everyone. Thank you very much for joining us as we endeavour to talk about the EU settlement scheme, barriers and solutions for children and vulnerable adults. My name is Grania Mellon. I'm a barrister in the public law team here at Garden Court, and I do a lot of immigration family crossover work and have been working on some EUSS cases for children in care. I'm also joined by Stuart McLachlan, who is from Quorum Children's Legal Centre and who, in his own words, has been drowning in EUSS applications for children and care leavers at Quorum. He is a Scottish lawyer who's been with Quorum for a number of years, and we're delighted to have him with us this evening. We also have Ollie Piercy, who is from Garden Court as well. He's formerly of the Public Law Project and was responsible for their still running EUSS Complex Cases Hub and has been involved in a range of litigation in relation to the EUSS. And he is going to be talking about late applications policy, the impact of COVID-19, and touching also on issues of applicants who lack mental capacity. We are also shortly going to be joined by Bojana Askanov, who is a barrister as well here in the immigration team in Garden Court. She is going to speak about the recent Zambrano judgment. She's been slightly delayed, but she will join us and she will be the final speaker this evening. And just to say, of course, many of you will be no doubt swamped and feeling the pressure trying to finish these cases before the deadline of next week. So please do ask any questions that you have in the Q&A, and also if there's any points of information or information sharing, please also put that in the chat, because I think we're all keen to hear about each other's experiences with the scheme. So thank you all very much. And I'm going to start now with a short presentation on some of the kind of basics in relation to children and care leavers. So I will just ask Amy to share my slides, if that's okay. And just to say, these will all be provided after the seminar as well. Okay, slide 1. Thanks, Amy. I feel like I'm on the Eurovision Song Contest. I think I said this before when I moved things along. In terms of a brief overview of the EU settlement scheme, I'm just going to fly through this. You all know it like the back of your hands, but obviously there are changes from the previous EEA regs regime in particular, and it's something, of course, which is a good thing, but there is no requirement to show that you have been exercising treaty rights for the purposes of the EU settlement scheme. It is simply nationality, family relationship, and duration of presence or residence in the UK. So that is a positive and more generous even than the withdrawal agreement. So we should acknowledge that. The other two changes are that it's of course not a right which is automatically acquired, but an individual has to apply under the scheme before next week. And also thirdly, there is now no physical document provided to those who've been granted pre-settled or settled status. So there are some of the differences between the EUSS, and obviously there's pre-settled and settled status, as I know you all know. Next slide, please. So one of the things which is most significant about this scheme is, as I've said, that it requires a proactive step to be taken on behalf of anyone who wishes to exercise EU rights going forward in the UK. And one of the real concerns, in particular for children and young people, is the consequences of that for them in terms of losing potential rights to reside, and thereafter the knock-on effects in terms of accessing healthcare, education, transitioning into independence, and just the real impact of this sort of cliff edge deadline. And what I think is interesting for us to remember and to take a step back and think about, even as the deadline is approaching, is that there's no comparable scheme has ever had 100% prospects of success with this model, and that's even without the constraints of the pandemic. So it's although everyone keeps saying must apply, I think what's important to remember is even if 1% of those eligible don't apply, the numbers will be huge, and the impact on those individuals will also be huge. So I suppose a starting point is just reminding us of the premise of the EUSS and the fundamental difficulties with that for many vulnerable EU citizens, and in particular children and care leavers. The next slide, please. So in terms of children in care in particular, and there are a range of complexities that are perhaps more acute than in other cases and even in other children cases. And some of the issues which come up, which I'll very briefly touch on, but which Stuart will also flesh out, and they've come up in some of the cases that I've been doing and that I know you will have too. So children unable to prove their nationality or length of residence, whether I'm thinking of a case I have of a homeless girl who thought she was British, but she is in fact French and can't prove it, doesn't have any passport, isn't in contact with her parents. We have babies in care whose parents aren't consenting to an application being made to the relevant embassy and are also not consenting to share information about their own immigration status. Children who may have either criminal convictions or serious pending criminal investigations. One that I have has not had a decision for 2 years pending further inquiries by the Home Office into those. And obviously one of the issues which increasingly comes up for many of these children who are born in the UK or have lived here for most of their lives is their entitlement to apply to register as a British citizen, and how that is managed alongside the need, and sometimes the very urgent need, also to apply to the EU settlement scheme. So there's a raft of different issues that apply to children, and they're more acute for children in care. And I think it's for this reason that there's been some really excellent research. I flagged 2 of the main reports on the slide. One of them is from Stuart and his team at Quorum, which is a really brilliant report on certain futures, and also some very recent research from the policy team at the Children's Society, who have highlighted, I think this was at the end of April, that more than 50% of identified EU looked after children and care leavers have not yet applied to the scheme. So I think that's improved slightly, but we're talking about huge numbers who still, it appears, have not applied, and huge numbers who haven't properly been identified. And as we all know from our casework, it's not always straightforward in terms of who has an EU law right or who is a citizen of an EU law country. So, or an EU country, just to flag some of those issues at this stage. Next slide, please. So in terms of the guidance, you'll all be familiar, just to flag some of the Home Office guidance on looked after children. And the main one is the first bullet point on the slide, looked after children and care leavers, May 2020. It only slightly tweaks, I think, the April version that was up. And it changes what was an expectation to a mandatory obligation on social workers to make these applications for children who are in care. And while, of course, that is positive in that it promotes local authorities taking proactive steps to regularise immigration status of children on their books, it does also raise, I think, difficulties. And I'd be keen to hear Stuart's experiences and any of yours about social workers making these applications, whether they are doing so and whether it's going well, because it is a big change in this guidance. It's not a change in primary or secondary legislation, and it is extremely difficult, I would suggest, for social workers to take on sometimes very complex cases. So it would be interesting to hear people's views on that. And there's also a Home Office survey which has been recently updated, and I've included the links to that. It identifies some recent statistics, none of which are particularly impressive, in relation to progress being made in applications for children in care. Next slide, please. And just to flag as well that there's the specific guidance for children in care, but there's, of course, obviously also the caseworker guidance, and it sets out a number of recommendations in relation to children generally, and also in particular in relation to alternative evidence of identity or nationality. And as we all know, a paper application form can be made for those who do not have a passport or an identity document, and there has to be an explanation of that. And the guidance sets out a number of criteria: either the document is unobtainable, from that it exists but cannot be produced, or that there are other reasons beyond the individual's control, or compelling, practical, or compassionate reasons. And as Stuart reminded me just before we began, thankfully, although very belatedly, paper forms can now be downloaded and sent in online, which I think is very helpful. And I think there was some discussion about what happens with photos and whether they can be sent in online, but I'll leave Stuart to fill you in on his latest thoughts on that. Next slide, please. And I just wanted to flag to anyone who had missed it that the Family Court has now weighed in on some of these issues, and this concerned 4 children in the care of 2 different local authorities, and they were subject to full care orders. And the local authority effectively applied to the Family Court for guidance as to if and how they were able to make an application to the EU settlement scheme on their behalf, and also apply for relevant passports from various embassies. And effectively, it's a ringing endorsement for local authorities progressing these applications as soon as possible by Mr. Justice MacDonald, and a very helpful decision generally on the importance of secure immigration status for children. And it comes up, as we know, particularly with care leavers and community care cases. And I really recommend this judgment in terms of reading it in full as and when you get the time. But it's really a reminder to local authorities that they have a duty to children in care to progress these applications, that they must do so expeditiously, that failing to do so has a real impact on the children in their care. And finally, that they can do so when a child is subject to a care order in the normal way under Section 33 of the Children Act without recourse to the court. So a really strong judgment from Mr. Justice MacDonald on some of these issues. Next slide, please. And I've just summarised here some of the things that we've talked about, which I have seen coming up in these cases, and no doubt you will have more. So we've talked about the lack of identification, including at local authority level, the lack of clear statutory guidance, in particular highlighting and signposting various complexities, particularly to social workers who may well be making these applications, difficulties obtaining legal representation, complexity of cases, and also the cost of British citizenship applications. Nearly all of the children that I've seen are likely to be able to make strong applications to register, but don't have the funds to do so. And that's another issue, which I know Stuart is also touching on. The question of the status which is given to children in care, perhaps babies 1 or 2 years old, getting pre-settled status instead of settled, huge delay and backlog in the decisions, late applications, which Ollie is going to touch on, and also this point about the right of appeal and when that kicks in, and what to do if an application was made before the date at which a right of appeal accrues. And I know what many of us have been doing is withdrawing and reapplying in order to preserve the right of appeal. So I just wanted briefly to flag that. Final slide, I think. Yes, solutions. I don't feel I have many apart from apply, which I know we all know. So obviously, when in doubt, apply. And I've also flagged the importance of preserving an appeal right if possible, including if needs be, by withdrawing and reapplying. I don't know what others are finding in relation to that. And then also just to flag some of the bigger issues about the scheme and drawing it back into what I've said about at the beginning in terms of the premise of the EU settlement scheme. It would be useful, I think, and I know Quorum and the Children's Society and many other charities are calling for things, including the deadline being extended, particularly in light of the pandemic, all out of time applications by children and care leavers being accepted with no further questions asked, and also settled status being granted to children or care leavers in particular. And of course, the ongoing issue of British citizenship fees and the process around that also rears its head when we're thinking about the reality of the choices facing these children and young people. So as you'll all know, there are 72, I think, grant-funded organisations who are helping with this. Quorum are obviously working very hard, and I wanted to give a special shout out to Here for Good, because I know that quite a large group of barristers have stepped in to help volunteer, join the Here for Good volunteer panel to try and help with capacity in these final weeks. So hopefully I won't get in trouble for saying that there may be some capacity there if you're still struggling to place some cases before the deadline. But thank you all very much, and I hope to have the chance to hear from some of you at the end. And I'm now going to pass over to Stuart, who's going to come in with some of his experiences on applications for children and care leavers.
Thanks, Grania. So I'm going to try and not cover really anything that Grania's already covered, but just kind of give an overview of some of the kind of practical implications we've found in terms of children making EU settlement scheme applications. Quorum has largely focused on children in care and care leavers, but I've also done some work with families, particularly those who may be supported under Section 17 of the Children Act 1989. Just briefly in terms of what we do, I don't want to spend a lot of time on this because unfortunately, as Grania's capacity is pretty limited now in terms we're just trying to get applications through, so we don't actually have an open referral process at the moment for EU settlement scheme, but we do have a free legal advice line, which is run by a solicitor called Alison, and we do have some guidance and resources on our website. In terms of some of the kind of practical or kind of issues relating to children and thinking really, I think I saw a couple of Q&As around what about children born in the UK, what about children in care orders. There's kind of two things. It's not just about EU settlement scheme applications for many children, particularly those born in the UK or have lived in the UK for a long time or who are in care. Like, there are actually questions here about actually also getting advice on citizenship as well, which really, with the EUSS guidance, social worker guidance that Grania was talking about, a social worker or maybe someone else who's not regulated is not going to be able to provide that level of advice. And it can lead to some complex questions and kind of a lack of clarity there for the young person, for the child. Because whether a child makes a citizenship application is slightly different to the EUSS, because the EUSS is something that needs to be done to protect their position as of post 30th of June 2021, while citizenship to some extent is a choice, and it has to be an informed choice for the child. And so it'll depend on the child's views, it'll depend on the nationality laws of the other EU country, because we've come across a number of cases where for some children it's not such a big issue where they can have dual nationality, but other countries in the EU have very strict nationality rules. So it's quite a difficult question there. And also whether the child has a root citizenship. If they were born in the UK, they'll have the 10-year route if they've stayed in the UK. But there's also the discretionary route for a number of children who've lived in the UK for a long time or who are care leavers or in some other circumstances. And also the differing if it becomes a care leaver. So if someone turns 18, do they lose some of those rights that they may have, like discretionary citizenship applications. And also issues over the cost, because there is a cost to British citizenship for children, although I know the PRCBC Supreme Court case is going ahead this week, I think. But at the moment, the fee is still there, and sometimes it can be an issue of who covers that cost, not just any legal advice related to it, but even in terms of children in care, will the local authority cover the cost, which they should do under their duties under the Children Act, but it can be a little bit complicated there. In terms of the actual EU settlement scheme, some of the issues we've had, particularly for children, is that they've got no ID or the ID is expired. That's kind of been our most common issue, one of those two. There are some cases where children have the ID, but quite often, particularly those children who've maybe been in the UK for longer, they don't have any identification. And getting ID documents was already difficult before the pandemic, and the pandemic has made it incredibly difficult. because children have maybe gone through multiple appointments or short notice appointments where they need to travel distances to embassies. Different embassies have different rules around needing to see certain information, like consent from both parents. They need the parents to attend. They need a birth certificate from the home country, or even that in some cases you need to see the shareable version of a court order. And then sometimes people aren't quite aware of what they are and aren't allowed to share from family court orders. So it makes it quite a complicated process. And as I say, the pandemic has really hit. For example, we've seen, we'll give an example, the Romanian embassy, where I think currently or recently they were talking about around 2 months for an appointment, and then up to 90 days for the issuing of an ID card or a first passport, which obviously is going to take you way beyond the deadline and will have for the last couple of months. So that's on the kind of identity side. If they have a birth certificate, that can be quite useful. Obviously, if they don't have an ID card, because then if they don't have a biometric ID card or an ID card, or they don't have a non-biometric and have to send it in, they'll have to use the paper form. And so often a birth certificate may be about the only thing that the social services or the child may have. So that can be used for identity, but otherwise you're looking at maybe a local authority letter confirming status. And I have to say my knowledge of outside of care situations is pretty limited, and most of the applications I've done have been children in care and care leavers. So we've had that backing of having at least a local authority letter to prove identity, because it is quite difficult if you don't have anything. But a birth certificate is a good starting point if that's obtainable. And with kind of residence evidence, it's more straightforward. I think for young children, it can be a bit difficult, particularly for those not in care, because you have less documentation in early years. If you're working with a family, then obviously the parents can assist with that. And also you may be able to obviously apply on the basis of your parents' rights, if they've got, for example, a longer period of status. Or you may be able to on the back of that. But for children in care, it's a bit more complicated. It may be possible, but really you're looking at local authority records and often school census records as well. I'm seeing a blank screen. I presume everyone else is as well. There we go. Okay. So just in relation to paper forms, I know Granny mentioned, so I think I should try and contain my rage here about what the current situation is with paper forms. So I know a lot of you'll know this, but as I say, there is the kind of the normal process you go through with an ID, and you use the app, and then you do the second part online. But for paper forms, historically, the issue was they weren't providing them ad hoc. You would have to contact the Settlement Resolution Centre and request a form that could only be used for that child. I think now realising just how many people haven't applied, and also how many applications are left outstanding, and the backlog and capacity with the numbers of people being able to answer calls, they started to open up the paper form process a bit more with grant-funded organisations. But now they then changed it further, and now they have got to a point where they've now published it online in the link that Granny linked on her slides. But that link is only for EU nationals or family members. If you've got a more complex case, like a derivative rights, etc., you still will need to request that, or you can also go, if you can get a grant-funded organisation to support, they will also be able to assist with that. So that's kind of your roots at that point. And the paper forms have gone through a number of changes. Issues with sending the application. What I mean by that is there were different rules at different points, particularly in the last month, about sending it, and then you can email it. But what I would say is, just if you're using the paper form that's currently downloadable, just follow the instructions on the paper form, because at the moment what it says is you can email the application to a specific email address, but then you have to send the documents, write some information on the envelope, and also include a brief note about the information in that envelope, and send it recorded or special delivery to a postal address. Or you can post the paper form with the evidence in one in one thing to a different email. It's a PO box, home office address. So what I'm just saying is make sure you read the instructions carefully in terms of what you're doing, because they're now given an option of emailing the application form. They briefly allowed like photos and things to be attached, but I think the attachments meant that they couldn't open all the documents because it exceeded the limit on the emails, I presume. So they've gone back to everything needs to be sent in document form, apart from you can send the application form by email. Yeah, and I guess in terms, some may be able to give this in more detail, but as to confirmations and waiting times, that is obviously going to be an issue for people, because with an app application, you're able to get that confirmation relatively quickly, but they have confirmed that you are protected as long as you make it before the deadline. And I just want to say a little bit about photographs, because they are a bit like, it's something that seems ridiculous, but it is quite difficult. I mean, because the form both refers to passport-sized photographs, but also digital photographs that meet the regulation requirements in the photo regs of 2016. It sets out in the form again, but just be wary of that, because it can be a little bit difficult, particularly if you're making an application for a baby or a very young child. Trying to get a photo of a baby who's not frowning or smiling can be quite difficult. It's not a kind of normal thing to have to do. Otherwise, one of our main concerns, and again, Granny picked up on this, is around the number of children not identified or who are going to have to make late applications or end of the line applications. And I think we've seen this a lot in kind of families and children who are supported at a more arm's length in terms of like kind of services, including maybe Section 17 families where they may be supported for a short period. The parent may get settled status, the support stops, but the child is actually still needing to make an application. With knowledge of kind of the wider EU rights, like retained rights, etc., and derivative rights, like many people don't necessarily know. They think it's just an EU national that needs to apply. They're not aware that there's others that can do as well. Local authorities, we're seeing better pickup. There has been a lot more, I know the numbers look low, and I think they are low, and inevitably children will miss out, but we are seeing local authorities. There's been a lot of work done to kind of help them identify, and I think both strategic migration partnerships, which manage large areas of local authorities, and local authorities themselves have tried to do a lot of work there to identify as many children as possible. But as I say, some may fall through the cracks just due to lack of knowledge. I don't have time to talk about children in the youth justice system, but that has been a nightmare from the start, and I think it continues to be so. But it requires a bit more specialised advice than I can probably give today. And then the different rules, and Ollie may mention this in terms of late applications and kind of the deadlines is slightly different, obviously, with babies born after the 31st of December 2020, and also babies born after 1st of April, on or after 1st of April 2021. There's slightly different rules for how long you have it. So, for example, if you're born on the 2nd of April, you've got 3 months from the date you were born to make the application. So there's a slightly longer period there. But inevitably, there's just going to be a continual move past the deadline of either late applications or applications that still need to be made. So that's just a quick overview. As I say, we've got our advice line and we've got some resources on our website if you do have any further queries.
Thanks very much, Stuart. That's really, really helpful. And thank you for explaining the difficulties with photographs. Who knew that we would need to spend time on something, but it's extremely important, and thank you for your insights on that. And now we're going to hand over to Ollie, who's going to speak about, helpfully, just on the screen as I come to it, EUSS COVID-19 guidance, mental capacity, and perhaps crucially, late applications.
Thank you very much. That was much slicker than when I did it in our tech rehearsal. Great. So the first thing that I'm going to speak to is what's been going on with the COVID-19 EUSS guidance, which, unless you've been following a niche part of legal Twitter closely, might have passed you by, but it is important, and it's likely to be one of the government guidance failures that leads to people not applying and having to apply late. Some parallels with the Zambrano issue that Biana is going to speak to you later. So I just briefly want to talk people through the timeline of COVID-19 and how it interrelates with the EU settlement scheme. All of us will remember when COVID happened and when we went into lockdown in March last year. But the Home Office did absolutely nothing in explaining what constituted an important COVID-19 related reason for breaking your continuous qualifying period, by which I'm sure everyone here knows this, but just as a brief reminder, if the ordinary position is up to 6 months out of the UK, fine, more than 6 months to up to 12 months, you need an important reason for doing so, otherwise you break your continuous qualifying period. And that is a serious problem if you haven't accrued 5 years of continuous residence in the UK, because it essentially resets the clock for your continuous qualifying period. If that happened after the end of the transition period, then bye-bye, your prospects of applying to the EU settlement scheme were in jeopardy. So just going back to this timeline, from really quite early in the pandemic, pressure from the sector was being applied on the Home Office, ILPA and others, Serifus doing an excellent job as well, in putting pressure on the Home Office to explain exactly what type of situation would COVID-19 be an important reason. We had the ordinary guidance of an important reason, but it hadn't been tailored to explain how COVID-19 interrelated with it, and it wasn't clear on the face of it. On the 15th of December, not a huge amount of time before the end of the transition period, one might say, being a solid 2 weeks, they finally issued some guidance, and it was terrible. And I will speak to that in a second. Following that, Here for Good challenged that guidance by means of judicial review, and I was fortunate enough to be one of the barristers that acted for them in that. They essentially conceded that, the Home Office essentially conceded that judicial review by pulling the guidance. And after some delay and contesting whether we could publish our acknowledgement of service with details of what the new guidance would be, eventually published new guidance on the 10th of June, which is broadly pretty good, although a couple of health warnings which I'll flag. The 30th of June is obviously the cut-off point, the grace period ending. So 20 days to go. The Home Office finally corrects its guidance about what constitutes reasonable grounds, an important reason for a break in your continuous qualifying period. An important reason for more than 6 months away so that it doesn't constitute a break in your continuous qualifying period. So this is the old guidance, and it doesn't, it's quite obviously bad. It uses a completely odd use of terminology that conflict with public health guidance, self-isolating being used entirely inappropriately there. Overall, it appeared to be extremely restrictive, and for many, you essentially had to be bedbound with COVID, is the conclusion that I drew from the guidance, or ill with coronavirus yourself, sharing a house with someone ill with coronavirus, or when required to self-isolate as a result of being in contact. Under quarantine conditions, it says, you had to be. Plainly, this was far too restrictive for what an important reason should be ordinarily construed as. It meant that people who were simply following public health guidance and avoiding flying, or were looking after vulnerable people who were shielding, were not caught by this, and as such would not benefit from having an important reason for more than 6 months out of the country. Here for Good collated numerous case studies of exactly how unfairly this guidance would operate in practice, and how many people had been disincentivized from applying to the EU settlement scheme as a result of it. So the new guidance, pretty good, although very late, being just 20 days before the applications closed to the EU settlement scheme. Now, I'm not going to repeat it on the screen, but I just want to flag that actually more than 12 months, not necessarily fatal to applying to the EU settlement scheme. So if you have more than a 12-month break because of COVID, you might still be able to apply. And that was far from the case under the previous guidance, which just talked about, which set a really narrow test for even having 6 to 12 months. Now over 12 months is in play. But just notice the slight distinction in wording between 6 to 12 and over 12 that's provided for in the guidance. Basically, 6 to 12, very broadly construed. There's a lovely catch-all provision that you can rely upon. Good luck, you should be okay if you can evidence it. However, it's stricter for more than 12 months, and any further time out of the country beyond 12 months, whilst it doesn't break your continuous qualifying period, it doesn't count as continuous residence. So yes, the term is coronavirus meant you were prevented from or advised against returning to the UK earlier. That's a tighter test, but we'll see how it operates in practice. Yet to see, because it's so recently published, this guidance, yet to see how it will actually be applied by EUSS caseworkers. So very much watch this space, but the main takeaway I want to sort of give people from this is, look, if you think you couldn't have applied because of COVID, read this guidance carefully and think again. And I'd encourage anyone who knows people who basically had given up on the EU settlement scheme because they were away for too long because of COVID, to, before the 30th of June, if at all possible, look at the guidance and think about putting that application in. So I'm now going to talk about late applications, the late applications guidance, which is set out in the EUSS casework guidance, and which was published at beginning of April of this year. So again, fairly recent and obviously untested as yet, because we're not at the stage of having late applications. I am particularly going to focus on how this interacts with individuals who have impaired mental capacity and might not have applied because of mental impairment. And this follows from a case that I did with Amanda Weston QC, a public law project, which was a challenge brought by migrants organised to the system in place for EEA nationals and their family members with impaired mental capacity applying to the EU settlement scheme. And in addition to what I'm going to speak to now in relation to the context of the late applications guidance, very much full credit to migrants organised for bringing this claim, because before they initiated pre-action protocol correspondence, there was literally nothing on, or very, very little on mental capacity in the EUSS caseworker guidance. It's now a fairly extensive guidance, which even covers individuals who are not subject to formal arrangements. And that only came about as a result of their challenge. Well, we think that it only came about as a result of their challenge. Suspiciously timed, if not. So the withdrawal agreement provides that if there are reasonable grounds for a late application, an individual can do so if they miss the deadline. Now, I just wanted to flag that this is indefinitely. It is not for a specific period of time, it is indefinitely. And particularly with the case of former children, so people who were children at a time when they might have applied, the caseworker guidance makes specific provision that it expects that they might not apply for several years. Similarly, with impaired mental capacity, if someone doesn't have mental capacity now and it doesn't recover for a substantial period of time, for example, they're in a they have dementia and are in a care home and go years without actually being checked or just surviving sort of under the radar of the hostile environment, just because it happens to be in years' time is no reason why they cannot rely on this late applications guidance. So just wanted to flag that it is indefinitely, and if we start to see Home Office gatekeeping in how they apply this guidance, we need to refer them back to the withdrawal agreement, which is directly applicable. So the really interesting part, I think, of this guidance, and more extensive than others in comparable areas of the immigration system, is the duties on immigration enforcement, positive duties to essentially avoid initiating immigration enforcement proceedings against EEA citizens and family members who would be eligible for the EU settlement scheme but have not put in an application for good reason or for reasonable grounds. So I've basically distilled what those duties are down onto a PowerPoint, but in short, they basically have to give an opportunity to apply. They won't determine the application whether the person they won't determine their reasonable grounds there and then. They're not. They cannot. They have to allow them to have an application. It's only when they make an application to the scheme. This notice must be recorded on a Home Office IT system. I highlight the word normally, just because this is slightly weaselly inserted by the Home Office in the guidance here. No immigration enforcement action for being in the UK without leave will normally be taken in respect of these people. We will have to watch this carefully to see what they actually do, because I guess that is some wiggle room for the Home Office. It's not an absolute prohibition. So if they think there's a family member that might have joined, etc., it's the same process that applies to them. It's not just EEA nationals who were here before the deadline. And yeah, if any of where the person makes an application under the Appendix EU and misses any of the important components required for that application to be valid, then they should be prompted to provide the evidence. And particularly as this is a vulnerable cohort that is likely to have missed the application with reasonable grounds, for example, people with impaired mental capacity, that seems to be a really useful reminder to immigration enforcement. And the guidance is fairly clear that actually the breadth of people that might possibly be eligible to the EUSS is extremely broad. Whether this actually is applied in practice properly is a matter that we will have to monitor. For example, if this is not known amongst all immigration enforcement officers, then there's a potential that some will just completely not recognise that they need to be looking to whether this might be a third country national family member of an EU citizen, and completely fail to apply this guidance, which I think is a real risk in practice. But at the moment, it's pretty good on the papers. It's more extensive than anything that I've seen in other areas, and we've got to assume good faith on the Home Office until proven otherwise. But it's a case of monitoring carefully. Now, the guidance provides non-exhaustive list of categories of individuals, including children and care leavers, and it's very deferential, particularly in relation to children, about the threshold for establishing reasonable grounds. And you do not need to look specifically at the reasons why a parent, etc., has not done it. Made an application. That they haven't done so should pretty much be enough. But just focusing on mental capacity for now, because that was the subject of the challenge that I was speaking to earlier, it's pretty good in terms of the evidence that might be used to evidence impaired mental capacity. And it doesn't say anything about having to establish constant lack of impaired capacity, which was a concern that we had, that the Home Office might come back and say, oh, well, you haven't evidenced it for every single impaired mental capacity or lack of capacity to apply every single day. Capacity fluctuates. Why didn't you apply when you might have on the dates when you can't, where you might have had capacity to apply, which you can't evidence? I mean, that might be what happens in practice. That might be the Home Office approach. They might require sort of a very granular approach to the evidence. On the face of it, that does not seem to be the case. And these are the suggested examples of evidence that might satisfy the Home Office as to making out impaired mental capacity as a reasonable ground for not applying. But it's not exhaustive, and we're just going to have to see what the Home Office's approach is going to be. And without wanting to sound like a broken record, we need to monitor closely, because what sounds good on paper might not be good in practice, and this guidance might not be followed as we would hope. But at the moment, we don't have the evidence for that. And that concludes my whistle-stop tour through COVID-19 and the EUSS settlement scheme, the later applications guidance, and with a particular focus on individuals with impaired mental capacity. Thank you very much.
Thank you, Ollie. That was really comprehensive and useful to know some of the more positive aspects of the guidance in relation to immigration enforcement. Thank you for that. And we're now, last but very much not least, we're going to hear from Bojana, who's going to talk about the recent Zambrano judgment that I know many of you have been asking about in the chat. So we'll hear from Bojana first.
Thank you very much. I can see that the time has gotten away from us a bit. I'm not sure if my little presentation has made its way to Amy. It's only a few slides. Do we have it? I gather not. I'm wondering whether I can succeed in sharing my screen. Marvelous, thank you. I will try to be as brief as possible. Obviously, these slides will be provided for anybody who's interested in more detail, but Akisanya was a very recent case where the claimants challenged a provision of the EUSS, which excluded people with leave granted under different provisions from qualifying under EUSS as Zambrano carers. Next slide, please. In this, Mr. Justice Mostyn found that there was no basis to find what Secretary of State had, both in policy and in EUSS, advocated that ruse Zambrano right is a right of last resort where nothing else exists. And that was on the basis of EU law definitions relying heavily on SANE, and also commented on misconstruction of the previous authority in Patel, as well as the wording of the EA regulations that Secretary of State misconstrued effectively in order to exclude this class of people from qualifying for the ruse Zambrano right of residence under EUSS. There was a number of other arguments that weren't ruled on, and in the concluding parts, the court observed the difficulty that the Secretary of State would be in with rewriting any rules in the future, given the position that they're in with respect to the preserved parts of the 2016 EA regulations, which the court found were crystal clear. Now, next slide, please. The order in this judgment is very important and very detailed, and I would recommend detailed reading of it. What the court has done is declared that both the Appendix EU and the Secretary of State's policy were erroneous. So people with leave granted in under other provisions of the rules are not excluded. This mostly bites, obviously, for people with Article 8 Appendix FM leave, which is granted on the basis of the same facts, such as either adult or child Zambrano carers. However, the Secretary of State is to reconsider, and that is the court order, the relevant provisions of Appendix EU. And in the meantime, the Secretary of State will not be considering cases which are materially impacted by the judgment. Now, that means that any applicants who have made their applications and are in this situation are looking at delay. We don't know how long the Secretary of State's reconsideration will take. However, in the meantime, any new policy following reconsideration will include a reasonable period for applications of people in those situations to continue being made. And that will amount to reasonable grounds for making applications after the 30th of June 2021. Now, there are three other provisions in the order. I'm not taking you through every single part of the order. There is a hyperlink to the judgment. At the end of it are all the orders. But three provisions which I think are really important is that if one makes a Zambrano carer application before the 30th of June, this will result in issuing of a certificate of application, which will permit the applicant to work, study, and enjoy a right to reside until the final determination of their application. Second, the Secretary of State will reconsider the position in relation to issuing similar certificates after the 1st of July in relation to all EUSS applications. So not just Ruiz Zambrano, but all the applicants applying out of time. This is obviously important because after the 30th of June, if a person hasn't made an application under EUSS, they're not protected, even if they come within the scope potentially of the temporary protection regulations, which fundamentally protect the position of persons who have a right to reside in EU law. But that is conditional on those people having the right to reside in EU law and having made the application in time. So potentially you have a group of people who are removable, subject to enforcement action, even though that shouldn't be happening. And they, in this context, have a potential for, at least after they apply, being protected, or at least the Secretary of State has to consider them being protected by way of a certificate of application. And finally, persons who are encountered by immigration enforcement, which come within the scope of Ruiz Zambrano right to reside, will have to be informed, will be provided with a written notice to give them the opportunity to apply. So this order is quite wide-ranging and very useful. However, The problem that one encounters in practice is that one wants their clients to be protected against any potential enforcement action in the chaos which might ensue. We hope not, given what Ollie has said about other provisions to do with out-of-time applications. So in order for them to be protected, we want all your clients, our clients, to apply before the 30th of June. So I hope that this is useful and that we still have some time for questions.
Thank you, Brianna. That's really useful. And I know that it will go some way to answering some of the questions in the chat. And thank you all for your questions. It's great to see that there are so many. If you do have some, please put them in the Q&A box rather than the chat box, just in case I miss them. I think we've probably answered most of what is in the chat. Let me just quickly see. We've provided links to the paper form and to the COVID guidance as requested. Here's one which I'll throw out to our panel members. What are the chances that the EUSS will be extended? I know there's been a lot of ongoing lobbying and policy work around that. And are DWP able to check on settled status, or do claimants have to provide evidence? The latter is a bit more straightforward, because the answer is that you can simply provide your national insurance number if that will work in your case. But what do you think about a possible extension to the EUSS? Anybody want to go first? Stuart's shaking his head.
I mean, I'm always cynical, so I don't know, because if it did happen, it would be very, very, very last minute.
Yeah.
And I just don't think it is. I think that late application process is what they're doing to cover it, to say, well, actually, you can still do it, and there's so many circumstances, and leaving it wide open. I just don't think they will. I'm happy to be proved wrong, but I don't.
Yeah, I agree. I think part of the reason we've got such robust late applications guidance, at least on paper, is so that they didn't have to do a last minute extension of the deadline, because the real prejudice the Home Office's argument that the real prejudice would be immigration enforcement action, and there are safeguards against that from happening. So I think it would be more a question of politics than law. I think it's very unlikely.
I think that's fairly unanimous that it's unlikely. So I'm afraid we all have to crack on with our applications before the 30th of June. One more question in the chat, which I'm sure Stuart or I can help with. I have a client who's a child, 2 years old, born in the UK. Mother and her older child have settled status, but the younger child has no ID. What's the best process for her, for the 2-year-old baby? Stuart, would you like to, or would you prefer me to?
I'm happy for you to. I mean, I think it'd be a paper form in that case.
Exactly, yeah.
And it's the last minute, so it's easy. You can. It might just be worth contacting the embassy if you want to double check it and just confirm with them that they can't give you an appointment or a passport within the time period, which inevitably is going to happen. Now, maybe there is an embassy that's given appointments within a couple of days and given passports within 72 hours, but I doubt it.
Yeah, I would encourage an application to be made for this 2-year-old sort of ASAP, as Stuart says, to download the paper application form and fill it in. There's a section where you can put in the UAN number of the mother, and if you want to, the other child, and ask for the same status essentially. And if there is anything from the embassy, as Stuart says, that you can attach, even if it's just an email to say that you've been in contact. But I think the sort of takeaway point is, apply, and even if you need to send any further reps or anything in afterwards, you can do so. Okay, and I'll just move to the Q&A.
I have seen a question about Fritilla.
Yes.
Could I just say one thing about Fritilla? We don't know what's going to happen, but Fritilla in the Supreme Court has been stayed. This is no great surprise, because there is a Northern Irish case, I believe it's CG, which was heard in May. The AG opinion is due in 2 days. And I suspect the judgment will follow not long after, and it is exactly on the same point as Fratilla. So it will no doubt be determinative and dispositive of what is before the Supreme Court.
Then there's a follow-up question, I think, in there about what happens, because Fratilla relates to the situation under the treaty. What's the situation under the withdrawal agreement? And I imagine if the Home Office re-legislated as per the question, then a challenge would be brought on the similar provisions under the withdrawal agreement. But wait and see, I guess.
Thanks, and thanks, Bojana, for highlighting the Fratilla question. There's a couple of Zambrano questions in the Q&A. I don't know, I think you may have answered them really. Will the new Zambrano case law permit adult British citizens to care for third country nationals under the EUSS? And a second question about whether, the applicability of it to parents of British citizen children outside the UK.
As to the first question, I don't think that's a Zambrano carer. It's the other way around. Sorry, what was the second question?
British citizen children outside the UK.
There are some difficulties with respect to that, insofar as the cut-off date is concerned. So because the specified date was the 31st of December, so this is the point at which the carer provisions are engaged. So if you're, it's my view is that it's evidentially probably problematic, but it's not. They are not within the scope of the family permit provisions, if I recall correctly. So it is a real difficulty as to enabling them access now. I'll be corrected by others if I'm wrong in this, but I've looked at it relatively recently, and I think that this is currently the situation.
Thank you, Bojana. And here's another one with late applications. If someone has an outstanding deport appeal to the tribunal under both EU law and the ECHR, is it better to apply to the EUSS now, or should an application be entertained after the appeal decision when they've got the tribunal determination? Don't know if others disagree. Bojana, I can see you were going to come in.
Yes, I was going to say apply now because you need to come within the scope of the temporary protection regulations. Even though that will be parked or refused, you just need that application in.
Yeah, I agree. And I think that applies to a number of the other questions. So we've been asked by somebody who's not given a name about an elderly EU national without ID. That would be similar to Stuart's answer in terms of the paper form needing to be filled in, and that should be going in before Wednesday next week, if possible. I mean, Ollie's helpful summary on late applications, but it's not something which anyone wishes to be relying on.
No.
What about applications to the EUSS? This is from Tom Griffiths, from children subject to care orders where one or both of the parents are querying the validity of the care order and therefore the gathering of evidence is problematic. There's actually so many questions. I think I've taken that one out of order. Would anyone like to go for that?
Yeah, I mean, I think in terms of the case you referred to in your slides, Grania, I think is where you go there in terms of the difference between a nationality application, and there was a case late last year around consent of parents, etc., and how important that was even in cases where there are care orders. But there is, I would refer to that case if anyone's trying to make the argument that they shouldn't make the application because the parents are being problematic. In terms of evidence gathering, we've had that. I mean, in many cases, like in some cases, the social workers managed to get a photograph of the ID document page, and we've submitted that along with what we could. In others, we've just had to submit what we can from the local authorities. You know, it's just what you can submit as much as you can and just give an explanation. Like in the paper forms, there's I think it's 2.4 around, although I don't quote me on that because I know the paper form's changing all the time, but there's a bit where you explain the absence, and you can also put in reps. So if there are difficulties and you're struggling with getting birth certificates, etc., you can go around that if there's lack of engagement. I mean, it could be the parents not engaging, but it also could be the local authorities not aware where the parents are, or they've had no contact with the parent.
Yeah, thanks, Stuart. And I agree, Tom. And I have one of these cases where there was a care order and the parents want to appeal it and are understandably very upset that the proposal is adoption. And really, I'm relying on a birth certificate, as Stuart says, and a letter from social services with the final care order. And because of the time, that's the best that we can do. But I think it's still, obviously, the overwhelming point is to get the application in, and as Stuart says, either deal with it on the application form or with short reps, relying on the Justice MacDonald case, which is very helpful on these points. Another one, has anyone been able to get legal aid to apply for EUSS applications? I don't know.
Yes. I know people that have got exceptional case funding. I think Quorum has. Stuart?
Yeah, not me, but my colleagues, yeah. Yes. I know my colleagues have. Yeah, they have. It is possible. I can just say it's possible, though. Maybe Ollie, you can say a bit more, because I have never looked at my colleagues' applications, but I know they have done it.
Yeah, so for the criteria for Section 10 LASPO, you need to make out at least a risk of an ECHR or retained EU law breach. Yeah, that. There are various criteria, but essentially you have to make out that it's complex, the importance of the issues at stake, and that the person wouldn't be able to make the application by themselves for those reasons. If you can establish that, and that there would be a breach of Article 8 in particular, is probably your best route in, you should be able to get exceptional case funding. But it takes time for it to be granted, and we don't have a huge amount of time left.
That is true, Ollie. That's depressing, but very true. I'm just trying to pick one.
I think there isn't enough time under the urgency provision for ECF to get it granted from today and get the application in.
Yeah, no, of course. There's quite a lot of individual case questions which we might not be able to get to, but just to touch on a couple in case it helps others. Client in hospital under the Mental Health Act and has no document. What can be done for him? I think we've touched on this. If you can make the application, even if you're simply relying on name and date of birth and proof that someone is in hospital under the Mental Health Act, I think the takeaway point, lest we sound like a broken record, is that that the application should be made with as much supporting evidence as possible. Has anybody else had any direct experience of that?
Again, I haven't, but my colleague has. And she has, I say successfully applied, there's not been a decision, but she has done it. So I could ask her and maybe that can be shared if there's anything. But she did manage to make it. So she has at least made the application.
Brill. And I think just one more question. I did promise that we'd try to finish by 6:15. It's from Nina, who, and this might be for Stuart and Ollie, but Brianna, please feel free to come in if you'd like to. Working with young people aged 16 to 25, but mostly adults in a supported housing setting. They are adults, they have capacity, but they do often have undiagnosed mental health difficulties and are generally vulnerable. Any guidance on what kind of evidence might be accepted in a late application? Any thoughts? Ollie, would you like to say first on the basis of the late application?
Yeah, well, essentially, the guidance is non-exhaustive, and the crux of it is you have to explain why you didn't apply. And if you can make a sort of nexus between the mental health condition, which you evidence by a doctor's letter, etc., and them not being able to apply, for example, they had anxiety about engaging with the process, that I think should be sufficient to have at least a chance of succeeding for having reasonable grounds. If not, that could be challenged. But the categories provided in the guidance and the evidence stated in the guidance are non-exhaustive. So it's worth a go, but try and get it in before if you can, so we don't need to rely on that.
I think that's a very sensible answer. Stuart, was there anything that you wanted to add, or did that cover everything?
No, I think that really covers it. I think there is the extent if they are in, supported accommodation or looked after under Section 20, or then there is also the extra arguments if they're in care, for example, as care leavers, they still have some protection.
Okay, well, I just turned to the other panel members and see if there was any questions in the Q&A that they had a burning desire to answer. Otherwise, I can see shaking head. Otherwise, I'm very sorry we haven't been able to answer all of them. There have been, I think, nearly 50, and it's great to see that everyone is engaged with the scheme. And obviously, I think the abiding point that comes through from the presentation is that there's still quite a lot of work, no doubt, for us all to do before the 30th of June. But I just wanted to say a very big thank you to all of you for joining us and for all of your work in this area. And of course, a big thank you to Stuart, to Ollie and to Biana for all of their presentations and their insights. And we will be providing a copy of the slides used, and also the recording will be sent to you and be up on YouTube as well. But thank you all very much and have a lovely evening.